Welcome to Employment Law This Week. I'm George Whipple. New Jersey's Warren Act is set to become the strictest and most punitive in the nation. Governor Phil Murphy has signed into law a set of landmark amendments which will take effect on April 10, 2023. Epstein, Becker Green's Marc Mandelman is here to explain what's changing in New Jersey.
There are four major notable innovations in the New Jersey Warren Act amendments. First, they impose a mandatory severance pay scheme, even if the employer fully complies with the advance notice requirements. If notice is issued even 1 day less than required, the employee is entitled to an additional 4 weeks of pay as damages. This is very different from the classical Warren structure, where the law was focused on providing employees advance notice, and damages would only be awarded if the employer failed to provide the employee with timely notice. Second, the amendments eliminate the classical scheme of requiring 1/3 of the full-time workforce at the worksite to be impacted for the statute to be triggered. Now, anytime an employer terminates 50 employees within the 30 or 90-day counting period, the notice and severance pay obligations will apply. Third, the statute eliminates the application of the law to terminations on a worksite-by-worksite basis. Now, in New Jersey, all involuntary terminations that occur anywhere in the state during the 30 or 90-day counting period are aggregated to determine whether the statute's thresholds are met. And fourth, the statute eliminates the part-time, full-time employee distinction. Previously, determining whether Warren was triggered involved counting only full-time employees. Now the lower trigger thresholds can be met by terminating a sufficient number of even recently hired and low-hour workers.
The mandatory severance that Mark mentioned is required even when an employer meets its notice obligations. These provisions are the subject of at least one federal court challenge, and it is unclear whether they are preempted by ERISA or other federal law. These provisions are of particular concern in light of the general trend towards lower thresholds in state Warren Acts.
The treatment of remote workers under federal Warren only partially answers the question and leaves open the issue of how this will be dealt with under state Warrens. This is likely something we will see sorted out through litigation or legislation. The amendments to the New Jersey Warren Act seem to touch on this point through elimination of the site-by-site analysis, counting all terminations within the state, regardless of what worksite the employee might be reporting into or otherwise associated with.
Thanks, Mark. And thank you very much for watching. We'll see you next time.